We are a peaceful people. Struggle is we struggle, and we don't look for trouble. Just ask around. But when outside faces from foreign places talk about taking over, we ain't backing down. We ain't giving up no mountains, we ain't giving up no tree, we ain't giving up no river that belongs to we. Not one blue sake, not one rice grain, not one caress, not a blade of grass. This land is all I know. We gonna make it somehow. We will bend like a bow and never break. Our fathers came here, and they lived and died here, and we ain't moving nowhere. Make no mistake, 'cause we ain't giving up no mountain, we ain't giving up no tree, we ain't giving up no river that belongs to we. Not one blue sake, not one rice grain, not one caress, not a blade of grass. We love the open country of the Rupununi and the Essequibo, the time when I eat. Though we may criticize it, this is our home, we love it, and we need to keep it. We have that right. So we ain't giving up no mountain, we ain't giving up no tree, we ain't giving up no river that belongs to we. Not one blue sake, not one rice grain, not one caress, not a blade of grass. So we ain't giving up no mountains, we ain't giving up no tree, we ain't giving up no river that belongs to we. Not one blue sake, not one rice grain, not one caress, not a blade of grass. We are a peaceful people. Struggle is we struggle, and we don't look for trouble. Just ask around. But when outside faces from foreign places talk about taking over, we ain't backing down. We ain't giving up no mountains, we ain't giving up no tree, we ain't giving up no river that belongs to we. Not one blue sake, not one rice grain, not one caress, not a blade of grass. This land is all I know. We gonna make it somehow. We will bend like a bow and never break. Our fathers came here, and they lived and died here, and we ain't moving nowhere. Make no mistake, 'cause we ain't giving up no mountain, we ain't giving up no tree, we ain't giving up no river that belongs to we. Not one blue sake, not one rice grain, not one caress, not a blade of grass. We love the open country of the Rupununi and the Essequibo, the time when I eat. Though we may criticize it, this is our home, we love it, and we need to keep it. We have that right. So we ain't giving up no mountain, we ain't giving up no tree, we ain't giving up no river that belongs to we. Not one blue sake, not one rice grain, not one can rise, not a blade of grass. So we ain't giving up no mountains, we ain't giving up no tree, we ain't giving up no river that belongs to we. Not one blue sake, not one rice grain, not one can rise, not a blade of grass. We are a peaceful people, struggle is with struggle, and we don't look for trouble, just ask around. But when outside faces from foreign places talk about taking over, we ain't backing down. We ain't giving up no mountains, we ain't giving up no tree, we ain't giving up no river that belongs to we. Not one blue sake, not one rice grain, not one can rise, not a blade of grass. This land is all I know, we gonna make it somehow. We will bend like a bow and never break. Our fathers came here, and they lived and died here, and we ain't moving nowhere, make no mistake. Cause we ain't giving up no mountain, we ain't giving up no tree, we ain't giving up no river that belongs to we. Not one blue sake, not one rice grain, not one can rise, not a blade of grass. We love the open country of the Rupununi and the Essequibo, daytime or night. Though we may criticize it, this is our home, we love it, and we need to keep it. We have that right. So we ain't giving up no mountain, we ain't giving up no tree, we ain't giving up no river that belongs to we. Not one blue sake, not one rice grain, not one can rise, not a blade of grass. So we ain't giving up no mountains, we ain't giving up no tree, we ain't giving up no river that belongs to we. Not one blue sake, not one rice grain, not one can rise, not a blade of grass. We are a peaceful people, struggle is with struggle, and we don't look for trouble, just ask around. But when outside faces from foreign places talk about taking over, we ain't backing down. We ain't giving up no mountains, we ain't giving up no tree, we ain't giving up no river that belongs to we. Not one blue sake, not one rice grain, not one can rise, not a blade of grass. This land is all I know, we gonna make it somehow. We will bend like a bow and never break. Our fathers came here, and they lived and died here, and we ain't moving nowhere, baby. giving up no mountain. We ain't giving up no tree. We ain't giving up no river. That belongs to we. Not one blue sake, not one rice grain, not one rice, not a blade of grass. We love the open country of the Rupununi and the Essequibo, daytime or night. Though we may criticize it, this is our home, we love it, and we need to keep it. We have that right. So we ain't giving up no mountain. We ain't giving up no tree. We ain't giving up no river. That belongs to we. Not one blue sake, not one rice grain, not one rice, not a blade of grass. So we ain't giving up no mountains. We ain't giving up no tree. We ain't giving up no river. That belongs to we. Not one blue sake, not one rice grain, not one chorus, not a blade of grass.
Honorable members, Mr. Speaker.
Thank you, honorable members. Please be seated. I now call on the honorable member, Ms. Nina Flo-Bess, to make her contribution.
Thank you, Mr. Speaker. Before I begin my presentation, I think it's befitting that we're going to talk about children. That I use this quote from Nelson Mandela that says, "Sports can create hope where once there was only despair. It is more powerful than governments in breaking down racial barriers. It laughs in the face of all types of discrimination." And this afternoon, I want to commend the Olympic team that went to represent Guyana. And I want to encourage my honorable members to give an applause for the team. Mr. Speaker, even as I follow on from my colleagues, I rise to add my contribution to this bill, Adoption of Children, Amendment Bill number 3 of 2021. According to Psalms 127, verse 3, children are a gift from the Lord, the fruit of the womb, a reward. Children are a fruit of the womb. Therefore, Mr. Speaker, in protecting such precious gifts given, we have a responsibility to ensure that our children's safety and future is adequately provided for. Unfortunately, we have several children who are faced with challenges. Some are living at institutions and others with relatives, yet are unable to enjoy the benefits of being loved and cared for adequately by a family. Mr. Speaker, adoption into the right family and environment is one avenue that can be used to make this possible. Our Constitution caters for this. In 38C, it says, the state shall ensure that the adoption of a child takes place only if that adoption would be in the best interest of the child. What does the best interest of the child mean? The best interest of the child simply means that the child's safety and health is protected, the child's education and developmental needs are met where possible, the importance of having a child in an environment where adequate care and respect for the child's cultural heritage is taken care of. Mr. Speaker, according to the law test, the journey of 1,000 miles begins with one step. Today, Mr. Speaker, is just one added step to the many steps already taken. The interests of individuals, organizations, and signing on to the Hague Convention would have been at the forefront in advancing these steps. As my comrades before me posited, all these steps were taken, and many, under the David Granger-led administration from 2016. Mr. Speaker, let me highlight some of the steps taken from several articles that were published and highlighted. There was a letter by Jamila A. Ali that was published in Stabroek News on the 24th of August 2000 under the caption, Amendment to Adoption Act is very badly drafted. And in the Guyana Chronicle on the 20th of August 2000 under the caption, Guyanese living abroad cannot adopt children here. Within these articles, it was posited that the former adoption laws did not permit Guyanese living abroad to adopt children, and it was not addressed by the amendment that was highlighted. Mr. Speaker, that tells us that work had begun on the act. On October 7, 2015, Guyana Chronicle caption, Guyana examines signing on to Hague Convention. This move was seen as strategic and beneficial to our country, according to the former Minister and Attorney General, Basil Williams. It was quoted, we are a cross-border country. Our people live in Brazil, Suriname, and Venezuela and establish relationships. You find a child comes back to Guyana with its mother, and usually the husband follows and claims the child was abducted. Hosting a Hague conference on family law, which deal with the private and international aspect in cross-border countries, definitely was seen as beneficial to us. Mr. Speaker, on July 2nd, 2016, the Department of Information captioned Guyana set to host Hague Convention Conference between July 13 to 15, 2016. A further step was taken at this conference by the Attorney General, where he nominated our Honorable Chief Justice, Madam Justice Yonette Cummings Edward, and Madam Justice Roxanne George to the Guyana's representatives on the International Hague Network of Judges. Mr. Speaker, these are just steps. On July 11, 2016, headline, stakeholders support ratification of the Hague Convention relating to children. DPI Guyana, Thursday 28, 2017, the Ministry of Legal Affairs has consulted with government agencies and civil society stakeholders as it considers ratifying child protection and other Hague Convention. Mr. Speaker, April 25, 2019, the World News caption, Guyana to implement the Hague Convention. However, this was stopped because of the non-cooperation of the then opposition, the PPPC. Mr. Speaker, I'm happy to see that steps will continue to be taken. On January the 15th, 2020, Newsroom captioned stakeholders in the areas of child protection on Wednesday came together to continue planning for the implementation of 4 international conventions on the rights of the child, namely child adoption, child abduction, child support, and child protection. Mr. Speaker, therefore, the Hague Convention improves the Adoption of Children Act. It provides the safeguards for adoption taking place between states. And it also caters comprehensively for what our legislation would not have catered for. Today, Mr. Speaker, is another step. Clause 3 seeks to amend the Principal Act by inserting under the heading Miscellaneous, Section 44 Offenses, which reads, proceedings for an offense under this Act shall be taken by the agency. And this will now be supported by 44A, which states that a person who commits a breach of this Act for which no penalty is expressly provided is liable on summary conviction to a fine of $500,000 and imprisonment for 6 months. This, Mr. Speaker, is simply saying the person can be taken before a court and proceedings will follow, and based on the judgment of the court, they pay a fine which does not exceed $500,000. Within the Act of 18, 2009, which was amended by 10 of 2011, the word offenses, when you Google it in the document, is mentioned twice, and the word penalty is mentioned once, and it simply says a penalty does not exceed $200,000 and imprisonment of 6 months. Mr. Speaker, could you imagine an affluent businessman whose business thrives on trafficking or committing crimes against children? Such an individual would definitely be using technology and will be researching. Countries where the law is perceived to be less severe will become an easy target. The individual can come, live, follow all the procedures, and commit acts against children or the child, but will only pay a fine which is equivalent to $2,500 US. Affluent businessman. Mr. Speaker, I believe more steps would have to be taken in the nearest future to further strengthen our act in order to further safeguard our children. In today's society, the possibilities of children being hurt are too numerous to mention. A simple Google search of possible crimes against children or specified offenses for which individual is deemed unfit to foster or adopt children will give you more than 100 offenses. Mr. Speaker, I recall the Honorable Member, Ms. Anil, presenting earlier that they would like to modernize our legislation. I would hope that the modernization will also take into consideration the fact that technology is playing a key role in crimes being committed against children. Therefore, Mr. Speaker, even though the Hague Convention will cover what's not covered in our act, I believe an entire section on offenses and penalties should be added to give our act more specifics about offenses and penalties, even though the Hague Convention covers that. This, I believe, would further safeguard our children on the matter of adoption. I therefore commend the subject minister for this continuous step and look forward to seeing more work being done to safeguard such precious gifts, our children. I thank you.
Thank you, Honorable Member. The Honorable Minister Vindhya Prasad.
I'd like to thank the members for their contribution to the debate on this bill. However, I must confess that, like my colleague, the learned Attorney General, I was confused as to whether ownership was being confused by the members of that side, in the sense that it was much vaunted that this was the work of the coalition, and then we are told of the myriad inadequacies that exist within this bill. I also want to say that the archaic first adoption bill of 1955 was amended by the People's Progressive Party Civic in 1997, and this allowed international adoptions. Just to correct the last speaker, who said that the current legislation does not allow international adoptions. I was at pains, and then later my colleague again, Attorney General, was at greater pains to explain that the process has been paused to allow what we are now doing to proceed. I also want to say that the whole point of bringing the Hague Convention into being by putting the force of the law behind it is because many countries have seen the wisdom. We too would like to ensure that children are protected and safeguarded at all times against all the ills and atrocities mentioned by both sides of the House. That's the point of the Hague Convention. And there were several benefits that were mentioned by those who spoke on the bill on this side of the House as to why we would like to bring this bill into being. And what came across was the obvious politicization of children. I mean, things like adoption. Whenever we're speaking about children, I think you need to take a step back and believe what you were saying. I stayed clear of it. I stayed clear of it in my presentation, and I think I also listened to all of you. I think, Mr. Speaker, the honorable members on that side of the House should sometimes stop to consider when we come here and we debate on issues dealing with children, it's time to leave the politics outside of the door, outside of the gate. You cannot come and want to call out everyone else when you are guilty of doing that today in this honorable House. Mr. Speaker, you know, sometimes it's easy to say, but when you speak the truth, others don't want to listen to it. And Mr. Speaker, I also want to clear up something. This part that we are engaged in was never brought to this House, so the People's Progressive Party Civic in opposition could not have stopped it. This is now, and this is when we are bringing this part to the House for it to proceed. In fact, the People's Progressive Party Civic, as a government, would have been not only in 1997 turning its attention to adoption by amending the 1955 Act, but they also turned their attention in 2009 by recalling the bill and submitting a bill that safeguards the interests of children across the country, which was later amended in 2011. We need to put facts as they are. And it is important to just set some of these facts right. And I think if you want to say things, they must be open to scrutiny and also commentary too, Honorable Member Mr. Ramjatan, through the Speaker. I want to say that as we speak on this very important bill, which I did not forget to mention, was acceded to in 2019. Of course, it is recognizing that both governments paid attention to adoption. Nothing is wrong with saying that and acknowledging that. And at this point in time, we need to make sure that when we are here to present, of paramount importance should be the interest, the benefit of all children in Guyana. And that's why we are here to ensure that this process can progress in the manner in which the Hague Convention intended it to. And that's why we made up the 100th of all of the countries that would have subscribed to this. I would like to say that as we continue to look at our legislation, whether adoption or any other piece of legislation, as it deals with children, it will require consistent review, revision, which can lead to amendment, and which can sometimes lead to repeal or recall and brand new bills, because time moves on, and this is the modernization that was referred to in the earlier presentation by the Attorney General. So it is this point in time that we try to harmonize our legislation with the Hague Convention. And I do remember a previous speaker mentioning, what about children, and children who are mature enough? If you can turn your attention to Article 4, and we look at D, 1, 2, 3, and 4, it does refer to the maturity of the child and that consideration be given to that child's wishes and opinions. Much of what was presented here would be contained in this new bill that would have been put here to the House. And it is because we value our children, we value their interests, and we want to see that adoptions continue, but continue through an inter-country mechanism in the best interest of the children, that very early when we got into government in November, this was first brought to the House. Okay? So, Mr. Speaker, I think much has been said. I would again like to thank everyone who presented, and I commend this bill to the House, and I hope there will be fulsome support of this bill. I thank you, Mr. Speaker.
Thank you, Honorable Minister. Excuse me. The House will now resolve itself. Sorry. I now put the question that the bill be now read a second time. Those in favor say aye. Those against say no. The ayes have it. Let the bill be read a second time.
Adoption of Children Amendment Bill 2021, Bill number 3 of 2021.
The House will now resolve itself into committee. Honorable members, I propose that Clause 1 stand part of the bill. I put the question that clause 1 stands part of the bill. Those in favor say aye. Those against say no. The ayes have it. I propose the question that clause 2 stands part of the bill. Honorable Minister of Human Services and Social Security.
I rise to report that the adoption of children
Honorable
amendment.
Minister, I think you have an amendment at clause
Yes.
2, 35C.
Yes, Mr. Speaker, I would like to propose the amendment, and I hope that that amendment, once considered, will be supported as part of this bill.
I propose the question that the amendment to clause 2, 35C stands part of the bill. I put the question that the amendment now stands part of the bill. Those in favor say aye. Those against say no. The ayes have it. The amended clause 2, 35C now stands part of the bill. I now propose the question that clauses 3 to 5 stand part of the bill. I now put the question that clauses 3 to 5 stand part of the bill. Those in favor say aye. Those against say no. The ayes have it. I now propose the question that the second schedule that's okay. I now propose the question that the second schedule stands part of the bill. I now put the question that the second schedule stands part of the bill. Those in favor say aye. Those in favor say no. The ayes have it. I now put the question that the bill as amended be reported to the Assembly. Those in favor say aye. Those against say no. The ayes have it. Let the Assembly resume. Honorable Minister of Human Services and Social Security, Dr. Prasad.
Mr. Speaker, I rise to report that the adoption of Children Amendment Bill 2021, Bill number 3 of 2021, was considered in committee clause by clause and was passed with amendment. I move that the bill be now read the third time and passed as amended.
The question is that the bill be read a third time and passed as amended. Those in favor say aye. Those against say no. The ayes have it. Let the bill be read a third time.
Adoption of Children Amendment Bill 2021, Bill number 3 of 2021.
Thank you. Honorable members, we will now proceed with the second reading of the Registration of Births and Deaths Amendment Bill 2021, Bill number 10 of 2021, published on 2021-0607. The Honorable Minister of Home Affairs.
Mr. Speaker, I rise to move that the Registration of Births and Deaths Amendment Bill 2021, Bill number 10 of 2021, published on the 7th of June 2021, be now read a second time. Mr. Speaker, honorable members, the most critical piece of paper, of parchment, if you will, in respect of citizenship of Guyana is the birth certificate. The citizenship of Guyana, to be vouched for, has to be proven by the submission of a birth certificate. And when there's joy at birth in all the far-flung regions of Guyana and on the coast, the obtaining of that birth certificate is a critical representation of citizenship. I want perhaps to start for perhaps a few personal anecdotes in relation to this matter. Fairly recent, I would say. A long time ago, when I was on a geological 4-month expedition on the Barama River, the Coromembu Hills, there was a family, the Cream family, who we lived with, and some of them worked with us on the project. And I would say the year is 1971. The family had there and then one of the young ladies who got married to our camp attendant later. And after many years, I met the now older woman, and she had difficulty in getting her birth certificate still. She had several efforts at it. She had the efforts purported of people who were interested in the matter. People took money from her to get a birth certificate for her. Lawyers took more money from her in respect of getting the birth certificate. And 3 years ago, I had to make it a personal mission of myself to get this person a birth certificate after so many years living a life of Guyanese in Guyana. And just recently, I went to Kurapung, and again I met a man I knew in passing over the years in the diamond fields. And he came to me and he said that he was now 82 years old and he still did not have a birth certificate. And so therein lies the problem, particularly in relation to our interior communities in respect of getting a birth certificate. And I think sometimes the process and the system works against people in the interior communities, particularly people who we have to acknowledge are the first people of Guyana, and who, by every means necessary, should obtain a birth certificate. I'm aware, while I hear some grumblings from the side, that the previous government did set up a Department of Citizenship. And this Department of Citizenship, along with the GRO, appear to be working in ways against the interests of persons who ought to have been given a birth certificate. One wonders sometimes when we chance upon occurrences like a few months ago when we discovered at the GRO the fake stamps for the franking of birth certificates and other documents. A fake and fraudulent stamp in relation to the franking of birth certificates. And even so, at the same time, I have to point out that since 2015 to just now, an amount of persons representing 10% of the population of this country entered and passed through Guyana and cannot be accounted for in the records of the immigration services. 10% of the population of Guyana, persons of all kinds, representing an amount. Mr. Speaker, our efforts now in bringing the amendments to the registration of births and deaths relate to strengthening the measures by which persons can validly be given birth certificates, that we expand the architecture in respect of places where people could get documentation to prove that they were born as Guyanese citizens, that we can ensure that there is a track record, that there's a paper trail in respect of ensuring that we could go back up the ladder, up the line, to assure that documentation which is presented is valid, that we speed up the ability of persons to get birth certificates. I know sometimes that there might have been a thinking that the delays in giving birth certificates in some areas may work against the PPPC, but in reality, it does not work against the PPPC. It works against individual Guyanese who have a right to having that first parchment, that first piece of paper in terms of identifying themselves validly, indubitably as Guyanese citizens. And so, Mr. Speaker, this bill seeks to clarify and simplify certain areas in the Act. An area of change is where an application is made to a magistrate to correct an error discovered in the entry of a birth or death in a registration form. We are aware that in many cases mistakes are made in the record, and that having seen the discovery of an error, it results in finding an opportunity for delays, for frustration, and sometimes for grief, and the giving up of persons in relation to obtain what is rightfully theirs in respect of having a birth certificate. In some cases, where there's a breach of the rule of law has been observed, in that an application before the magistrate, the registrar was not given a hearing. This has been addressed in this bill. This bill identifies the types of errors that the magistrate may correct. The bill, this unnecessary restrictive provision limiting the time within which a late name child's name in the registration form must be made, and the necessity to appear before magistrate to have this entry done have been removed. The law, Mr. Speaker, against the discriminatory practice of issuing a differently colored certificate of birth for an adopted child for any certificate issued for non-adopted children has been clearly set out by this amendment. Mr. Speaker, Clause 2 of the bill amends the Act by inserting a new Section 34, which provides for a parent to choose any surname for a child. Clause 3 amends Section 35 of the Act by substituting a new section to enable the name of the child to be entered on the registration form at any time after the birth has been registered for the child who attains the age of 18 and over to also apply for insertion of a name. It removes the time limit of 12 months from the date of registration of birth in respect of late entry of a child's name in the registration form, and sets out a simpler and more convenient process to be followed for the entry of the name of a child where the child is registered without a name and the child is subsequently named. This amendment also removes the requirement that a magistrate must by order direct this insertion of name. Mr. Speaker, Clause 4 amends Section 43 of the Principal Act. In 43.2, it substitutes for the words, if any error, the words, if any minor clerical error, and provides for errors discovered in a sealed certificate of birth or death be corrected in the same manner as a registration form is corrected under that section. This is a necessary amendment as most of the time errors are discovered in the particulars entered in certificates of birth or death rather than the registration form. And 43.3 is amended to provide for the Registrar General to be given a hearing when an application is brought before a magistrate for correction to any erroneous entry in the registration form or certificate of birth or death. In this section, Mr. Speaker, the rule of natural justice was always implied. It is now specifically stated. This amendment would ensure that before the magistrate orders the Registrar General to correct an error, the magistrate must afford the Registrar General the opportunity to inform the court of the information on the register as regards the request for the correction. 43.4 amends to provide for the previous incorrect certificate and the new certificate to be kept as a record in the registry for validation purposes. The bill inserts a new subsection 3 into section 43, an important provision which ensures more detailed information of the errors and their corrections are kept for future reference. Similar requirements are made in section 43.4 before its deletion by Act 21 of 1990. Mr. Speaker, Clause 5 amends the Act by inserting a new section 44A, simplifying the process by which an adult who has no original documents may acquire a certificate of birth on the basis of the presentation of certain documents containing particulars of birth. This can be achieved, for instance, by a statutory declaration by a person of high standing in the community, including a community leader or tushao, or any other document with information indicating particulars of the birth notarized by a notary public. Likewise, this clause provides how a certificate of death for an adult where original documents may be obtained. Clause 6 amends Section 49 to provide that the Registrar General shall issue a certificate of birth or death within 45 days from the filing of the original registration form of birth or death. And Clause 7 amends the Principal Act to insert a new Part 6A entitled Registration of Adoptions, consequently providing for registration of adoptions, which has been provided for by Part 5 of the Adoption of Children Act, Chapter 46, 4. The new Part 4A comprises Section 65B, which includes a provision that seeks to remove without a doubt the discriminatory practice of issuing a differently colored certificate of birth for an adopted child from any other certificate issued for non-adopted children. Mr. Speaker and honorable members, for too many people who do not have a birth certificate, the acquisition of a birth certificate, the process could be a very vexatious, tedious, and also discriminatory process. It also has implications with respect to the time and cost and the effort with which people who should carry a valid Guyana birth certificate have in obtaining such a birth certificate. And not simply only the birth certificate, but for relatives, for families who would be trying to get certificates of death, which may have issues in relation to the probating of wills and inheritance issues. The amendments we propose provide a simpler pathway, one with more integrity, one with which there is the means to check and to validate the background documents in respect of the issuance of a birth certificate. And so, Mr. Speaker, I propose the motion and I encourage honorable members to weigh in on it. Thank you.
Thank you, Honorable Minister of Home Affairs. I call on the Honorable Member, Ms. Amanza Walton Desir, to make her contribution.
Sell that to me outside, Kwame. Mr. Speaker, thank you. I rise to make my contribution to this debate on the proposed amendments to the Registration of Births and Deaths Act, Chapter 4401, as contained in Bill number 10 of 2021. I'm appreciative of the invitation from the honorable member to weigh in on it, because weigh in on it we shall. Mr. Speaker, I tried listening earlier to Honorable Member Teixeira. She waxed about democracy prevailing and the success of democracy, and that on the 2nd of August, democracy prevailed. But in actuality, Mr. Speaker, what prevailed on August 2nd, 2020 was a kleptocracy, defined by the Merriam-Webster Dictionary as a government by those who seek chiefly status and personal gain at the expense of the governed.
Honorable members, I would like to hear the honorable member go through with her definition, because I might want to weigh in.
I appreciate that, sir. I thank you. I shall repeat for the avoidance of doubt, Mr. Speaker. The kleptocracy is defined by the Merriam-Webster Dictionary as a government by those who seek chiefly status and personal gain at the expense of the governed. In case that is unclear, the Cambridge Dictionary defines a kleptocracy as a society whose leaders and government make themselves rich and powerful by stealing from the rest of the people. This is why, Mr. Speaker, hard-working public servants cannot get a salary.
Thank you, Honorable Member, but I know after listening to you, August the 2nd, I can't recognize as any kleptocracy, and I'd ask you to withdraw it. That being, I'll tell you why. I consider myself appointed to this position by a duly elected parliament. Thank you.
Mr. Speaker, I must say that we must bear in mind in this...
Honorable Member first, I'm asking for honorable members on my right. I'm trying to speak. Yes. Honorable Member.
I am unclear as to what you were saying, Mr. Speaker, because I am operating on the presumption that we live in a society where there is a separation of powers.
I am operating on the fact that I asked you to withdraw.
The legislature
I asked you to withdraw the comment that you made.
Notwithstanding, Mr. Speaker, I shall withdraw.
Thank you very much. Honorable Member, you may proceed.
Thank you, sir. Mr. Speaker, as I was saying, based on the modus operandi and the nature of the installed regime that I just described, this is why public servants can't get a salary increase after 2 budgets, and this is why, even though we have the fiscal space to do so, the installed government refuses to enact the necessary measures to bring considerable relief to the Guyanese people. Mr. Speaker, I will say before I go to the consideration of the bill before me, as I have the floor, that when listening to the Honorable Member Teixeira and the Honorable Prime Minister this morning, I am convinced when I listen to the level of delusion, I am more convinced now than ever, Mr. Speaker, that we live in 2 separate Guyanas. 2 separate and distinct Guyanas, Mr. Speaker. One, where the installed government, their families and their cronies continue to line their pockets at the expense of taxpayers. And the other, Mr. Speaker, the other Guyana being the one that the majority of Guyanese reside in. The one where Guyanese have to cut and contrive to afford 3...
Honorable Member, let's hear the Honorable Minister of Home Affairs.
Mr. Speaker, standing order.
40A. I would like to suggest or encourage the honorable member to speak on the motion proposed at hand.
Honorable Minister, I don't recognize that as a valid point of order. Honorable Member, please proceed.
Thank you for your protection, Mr. Speaker. I'm reminded of the comments of the Honorable Member Prasad, in which she said that truth has to be spoken. And so I will proceed to speak the truth, Mr. Speaker, because the truth is we are living in 2 different Guyanas. And like I said, one exists where this government and their families and cronies live in luxury, and the other one is where the ordinary Guyanese has to cut and contrive to afford 3 meals a day, because everything in the market continues to rise, Mr. Speaker. Gas prices are rising every day, Mr. Speaker, and Guyanese must and are forced to cope. Having said that, Mr. Speaker, I wish to turn my attention to the proposed amendments as set out in the explanatory memorandum, Mr. Speaker. The bill purports to clarify and to simplify certain parts of the Principal Act. I want to say, Mr. Speaker, from the outset that we on this side of the House unequivocally support a system of registration of births and deaths that is as simple and straightforward as possible. We avow, Mr. Speaker, that every individual has the right to have legal recognition of their existence through registration of their birth. Indeed, the Rights of the Child Convention, to which Guyana is a state party, provides in Article 7 that a child shall be registered immediately after birth and shall have the right from birth to a name, the right to acquire a nationality, and as far as possible, the right to know and be cared for by his or her parents. It imposes a duty on state parties, Mr. Speaker, to ensure the implementation of these rights in accordance with national law, and in particular, where a child would be otherwise stateless. Mr. Speaker, Article 8 says that state parties must undertake to respect the rights of the child and to preserve his or her identity, including nationality, name, and family relations as recognized by law without unlawful interference. Mr. Speaker, a person's identity is to a great extent bound up with paper, as my colleague on the other side of the House alluded to when he spoke. Whether it is a passport or a birth certificate, identification documents are legal proof of who we are and are essential to modern life. Archbishop Tutu said of birth registration, it's a small paper, but it actually establishes who you are and gives access to the rights and the privileges and obligations of citizenship. Mr. Speaker, we on this side of the House have a track record that speaks for itself. Through a number of programs and partnerships with international organizations such as UNICEF, the coalition sought to address the deficiencies in the institutional and policy frameworks, including access to services. According to a UNICEF report published on its website in February of 2020, it says, with the support of UNICEF's mapping program, between 2016 to 2019, the General Register's Office has gained access to many remote areas of Guyana. The country now has an improved record of properly registered births, a total of 89% of the population. That, Mr. Speaker, is our record on this side of the House. Mr. Speaker, I will attempt to, clause by clause, address the provisions of the bill before us. Clause 2, sir, seeks to insert a new Section 34 into the Act and says that a parent may choose any surname for a child. Mr. Speaker, while on the face of it, this appears to be a very forward-thinking and progressive piece of legislation, we must appreciate in this House that our laws must reflect the realities and the values of our society. We must, as legislators as well, ask ourselves when prescribing laws, what is the mischief? What is the defect that is there to be corrected? I would want to propose for the consideration of this House, Mr. Speaker, that the provision as existed was sufficient. And I'm sure one of my colleagues will go into far greater detail on that particular provision. And I want to recommend for the consideration of this House that if we are going to consider this provision, that it be in addition to and not in substitution for the existing law. Mr. Speaker, even as it stands, this provision that provides that a parent may choose any surname for a child, it is my submission that it is likely to cause some confusion if left on its own without more. The reality is, Mr. Speaker, that in our society, in our culture, a surname plays an important part in securing a person in their identity, in their sense of belonging, Mr. Speaker, and therefore we cannot approach it in a cavalier manner. Mr. Speaker, I'm sure every one of us in this House has had the experience at home and abroad of meeting someone with a surname similar to ours. And immediately, Mr. Speaker, the clarifying questions come. Where your family from? Where you from? Who's your mother? And if you're abroad, in the words of the Calypso, when last you been home? Mr. Speaker, this is what we experience on almost a daily basis. But at a deeper, at a more fundamental level, it goes to the question of identity. The name and the surname that you carry in our society is something that is weighty and ought not to be treated in such a cavalier manner. And so I want to suggest, Mr. Speaker, that we maybe seek to amend this provision in its current form to make it very clear what the implications of it might be. For example, we may want to clarify, Mr. Speaker, that If a parent chooses a name for a child, it does not carry with it a particular connotation. For example, a particular surname is not prima facie indicator of paternity, for example. These are considerations that we must take account of. A practical question could arise, Mr. Speaker, since a parent has a right to choose a surname. What if two parents disagree as to what a child's surname would be? What then? What is the mechanism for dispute resolution? I think, Mr. Speaker, these two examples indicate that much more thought is required to ensure a properly crafted provision that is capable of implementation. Mr. Speaker, clauses 3 and 4, which seek to amend sections 35 and 43 respectively, are straightforward. And as the honorable member before me said, these are intended to simplify the system. And I'm satisfied, Mr. Speaker, because I have seen that this is a provision that is present in many other jurisdictions within the Commonwealth Caribbean, and some would have implemented this type of provision as early as 2012. Mr. Speaker, it is indeed commendable that we are seeking to remove discrimination against children who are adopted by ensuring that there is no distinction in color of the birth certificates. The only caveat that we would have, Mr. Speaker, is that the establishment of a register of adoptions will necessarily occasion an administrative burden, and so we would want to make sure that all their administrative arrangements are in place so that this function can be properly executed. Mr. Speaker, clause 5 sets out in the explanatory memo that it purports to simplify the process by which an adult who has had no original document may acquire a certificate of birth on the basis of certain documentation as prescribed. Mr. Speaker, clause 5 specifically references the following documents. 1, a declaration in a prescribed form signed by a person of high standing in the community, including a community leader or Toshao. Mr. Speaker, as a legislative drafter, one of the chief rules is that you must seek to be as clear as you possibly can. And as I stand here, Mr. Speaker, it is unclear to me what is meant by a person of high standing. I think we may need, for the purposes of clarity, to specify exactly what we mean. Mr. Speaker, the second document says a declaration under the Statutory Interpretation Act by a person of high standing in the community, including a person of high standing again in the community, including a community leader or Toshao. This declaration has to be signed by a justice of the peace or a commissioner of oaths, and the declaration must state the particulars of the birth of a person. Or 3, the final prerequisite, any other document with information, including a certificate of baptism or information in the marriage register. Mr. Speaker, I know that it says or, which says that it could be any one of these 3 that would satisfy the requirement and trigger a legal duty on the registrar to issue a birth certificate. Mr. Speaker, as I said earlier, a birth certificate, though a small document, is an important one. We must note, Mr. Speaker, that the registration of a birth is both a means and an end. As an end in itself, birth registration is a fundamental right of every newborn to an identity. As a means, it is a vital record and is linked to access to social services, a political identity, and citizenship of the respective state. In studying this provision, Mr. Speaker, I am reminded of that myth in Greek mythology, the story of the Trojan horse. As you know, the Trojan horse was a huge hollow wooden horse constructed by the Greeks to gain entrance into Troy during the Trojan War. The horse was built by one Epeius, who was a master carpenter and pugilist. The Greeks, pretending to desert the war, sailed to the nearby island of Tenedos, leaving behind Sinon, who persuaded the Trojans that the horse was an offering to their goddess Athena, which was the goddess of war. This offering was to have made Troy impregnable. Despite the warnings of Cassandra, the horse was taken inside the city gates. And as the story goes, Mr. Speaker, that night, Greek warriors emerged from it and opened the gates to let in the returned Greek army, resulting in the defeat and destruction of Troy. The term Trojan horse, Mr. Speaker, has come to refer to subversion introduced from the outside. Beginning in the late 20th century, Mr. Speaker, the name Trojan horse was applied to deceptively benign computer codes that seem like legitimate applications, but are written to damage or disrupt a computer's programming. I say all of that to say this, Mr. Speaker, that this provision is a Trojan horse. Mr. Speaker, wrapped up and lost away in other seemingly useful and progressive provisions. This clause, Mr. Speaker, provides the ultimate opportunity for mischief, and it is perhaps the cornerstone that is being laid to ultimately and possibly irreversibly subvert the will of the people of Guyana again. Mr. Speaker, the loose manner in which this provision is crafted provides a means for any person to be registered as a born Guyanese, having established only the most tenuous of ties. What compounds it, Mr. Speaker, is that there is no serious penalty for someone who would seek to take advantage of so loose provision. Mr. Speaker, to make my point, I went and I researched within the Commonwealth Caribbean. And what we see, Mr. Speaker, is that in neighboring Trinidad and Tobago, for example, we do not have to go far, just neighboring Trinidad and Tobago, we must see the seriousness, and we can see the seriousness with which such a matter ought to be treated. Where a person, Mr. Speaker, in similar circumstances, wishes their birth to be registered, they must provide the following documents. If the birth was as a hospital, Mr. Speaker, they must provide a letter from the hospital stating the date of birth of the child and the name of the parent. They must provide a statutory declaration from the applicant, giving particulars of their birth and the reason for non-registration of same. They must produce, Mr. Speaker, if possible, an immunization card. They must produce, Mr. Speaker, a letter from the school they attended. They must be able to, Mr. Speaker, if the parents were married, to produce a marriage certificate and particulars of that marriage. And, Mr. Speaker, if possible, they are required to provide the birth certificates of children born before or after who are to be registered. That is, if, Mr. Speaker, the person was born in a hospital. If born at home, Mr. Speaker, they must present an immunization card. If parents were married, the marriage certificate should be presented. Birth certificates of all children before and after birth should be presented. So if I'm applying, I will have to indicate who my siblings are, etc. All of this is going to establishing identity. And, Mr. Speaker, there must be some form of identification of the applicant. There has to be a letter from the school stating the date of birth given at time of entry to school. Because, Mr. Speaker, we agree that in the normal course of things, an adult would have had to or should have attended school at some point in time, and so the school must have some kind of record. Notwithstanding that in some jurisdictions you can register a child without a birth certificate, there are specific provisions which would allow you to establish, as it were, some tie to an early education institution, Mr. Speaker. Mr. Speaker, in some jurisdictions, you're required to present a baptismal certificate, an affidavit from the mother or father if the person is still alive. Mr. Speaker, you're required to present an affidavit from a person present at your birth. So if your aunt or your grandmother, the midwife, your chachi, your mommy, or your aji, if they were present there, they have to swear to an affidavit. And then lastly, Mr. Speaker, affidavit from a prominent person in the area which the child was born, and they go on to specify exactly what that means. Example, a doctor, a lawyer, a teacher, a priest, a pandit, or a police officer. Mr. Speaker, it is important to note that we are proposing to confer a registration of birth using only that last criteria, Mr. Speaker, and that is completely unacceptable, sir. Mr. Speaker, if we contrast this with the lax requirements of Clause 5, we come across, I can't help but come to the conclusion that mischief is afoot, Mr. Speaker. These provisions are far too lax and far too permissive for us to take them seriously and for us to construe them as an honest intent to remedy a situation where a person may or may not have a birth registration. Mr. Speaker, I know that much to the dismay of my colleagues on the other side of the House, I believe, sir, that mischief is afoot. And I believe, sir, that there is every intention to use these provisions to confer registration of birth and birth certificates of persons who may not very well be entitled to them, Mr. Speaker. Mr. Speaker, I will say, and it is fortuitous that the member that went before me specifically referenced those far-flung hinterland communities, Mr. Speaker, because this is what I will say. It's no secret that we share a porous border. There is no secret, sir, that there are over 50,000 Venezuelans in Guyana. It is no secret, sir, that these migrant groups are vulnerable to political pressure. Mr. Speaker, I will say that I believe, sir, that this is what is going to happen if we approve this today. Mr. Speaker, if this bill is passed in its current format, this is what will happen. Conveniently, sir, and covertly, there will be thousands of new birth registrations, particularly affected in those far-flung hinterland regions, using an established network of PPPC-aligned justices of the peace, notaries public, and toshals. Then, sir, once a desirable number of new registrants are reached, including a make-safe number, once this has been achieved, Mr. Speaker, what we will see is a sudden epiphany that there is a requirement for house-to-house registration. That is what will happen, Mr. Speaker, because house-to-house registration will be effected when you would have had thousands of persons in possession of a birth certificate and therefore entitled as of right, Mr. Speaker, to be entered onto a voters list. So, Mr. Speaker, we see behind this ploy, what this is a ploy, Mr. Speaker. And so we cannot, sir, in this current iteration, we cannot support this bill in its current iteration, Mr. Speaker. Mr. Speaker, as I said before, the issues of birth registration is important. Mr. Speaker, we are aware, as I alluded to Venezuelans earlier in the in my speech, there are Venezuelans or there are Guyanese who migrated to Venezuela and because of the humanitarian crisis are seeking to return home with their children. These are not the persons of whom I speak. I am speaking of those, Mr. Speaker, who could, for all intents and purposes, with a complicit toshal, with a complicit justice of the peace, with a complicit commissioner of votes to affidavit, acquire a Guyanese birth paper, when they are not entitled one, Mr. Speaker. Mr. Speaker, as I have the floor, I want to say that the handling of the Venezuelan migration, and indeed migration to Guyana, cannot be a matter that is dealt with in abstract. This is a nation which we have had for decades, sir, a simmering border controversy, and which directly touches and concerns our sovereignty. Mr. Speaker, we in this honorable House are acutely aware that our sovereignty and our territorial integrity can be undermined through the use of force by that neighboring state that has a far superior army to ours. But, Mr. Speaker, we must also be cognizant of the fact that our territorial integrity can also be undermined by the insidious incursion of thousands of persons pouring across our borders as refugees, and establishing, Mr. Speaker, settlements in the Essequibo, which, Mr. Speaker, they have been taught from the time they could read belongs to them. Mr. Speaker, we must in this House take this matter seriously. We must assess it, sir, for the clear and present danger that it poses to our country and to the people of our country. Mr. Speaker, as a nation of less than 800,000 persons, it does not strain credulity, sir, that a nation of over 28 million with a humanitarian crisis and resulting in thousands of refugees pouring into our country could easily result in a situation where Guyanese are outnumbered in their own country. It is entirely possible, Mr. Speaker, and I would encourage that the time for a national conversation on migration, the treatment of migrants, and the path to Guyanese citizenship, particularly in view, sir, of the development that we project, Mr. Speaker, that the time for this national conversation is now. Unless decisive action is taken, sir, Guyanese could very well find themselves relegated to second-class citizens in their own country. As for this bill, Mr. Speaker, I cannot support this bill in its current format. I reiterate our support for a registration system that is simple and that is easy, but we cannot condone one that will give rise or could give rise to mischief, sir. And so I call on this House to reconsider this bill in its current format. I will say once again very clearly that I believe that Clause 5 of this bill is a means of subverting the democratic will of the Guyanese people, and I therefore cannot in good conscience support it. And I call on every Guyanese to take notice of this bill, to take notice of its intention, to take notice what can be the result if it is implemented in its current format, and to raise their voice against what I consider to be wickedness and subterfuge. Thank you, Mr. Speaker.
Thank you, Honorable Member. I now call on the Honorable Member, Mr. Alistair Charlie, to make his contribution.
Thank you, Mr. Speaker. In short response to the Honorable Member that just spoke before me, I just want to say it is a norm in this House that the opposition members of Parliament lacks basic comprehension. Basic comprehension, Mr. Speaker, and I won't elaborate anymore. Mr. Speaker, go pay your court's bill. Mr. Speaker, I wish to join my esteemed colleagues on this side of the House and to add my contribution to the Registration of Births and Deaths Amendment Bill, number 10 of 2021. Mr. Speaker, This amendment bill will handsomely address the woes of the Amerindian and hinterland residents across Guyana. The people who face hardships in obtaining a birth certificate or a death certificate. The honorable member before me was highly suspicious, but forgot the role and function of the Ministry of Citizenship, what that ministry did during its tenure. Mr. Speaker, the Principal Act is amended by the insertion immediately after Section 44 of the following new section, where an adult has no original document. 44A1, where an adult requires a certificate of birth and there is no original document containing the particulars of his birth, or there is no record of his birth, the Registrar General shall issue a certificate of birth on the basis of any of the following documents containing particulars touching the birth. A declaration in Form 3A or to the like effect, signed by a person of high standing in the community, including a community leader or a tushal. Mr. Speaker, the Amerindian community welcomed this move by the PPPC government in this amendment. Amerindians and hinterland residents face lots of hardship. In remote areas where a birth certificate cannot be acquired, financial constraints to get to Georgetown is another issue. Tushals having that power, and I would like to educate the honorable member before me that a tushal is one of the high-standing persons in his community, and also is a justice of the peace. So automatically, he or she, the tushal, is a high-standing person. Mr. Speaker, this amendment bill, as I said before, will empower the respective Amerindian village leader to sign the declaration Form 3A. Mr. Speaker, this is some of the interventions of the Dr. Mohammed Irfan Ali-led administration to bring relief to the Amerindian and hinterland residents. Mr. Speaker, I can go on and on. We all know the hardships our Amerindians and hinterland residents face, and with this intervention, once again, Mr. Speaker, it will definitely bring a relief to our people to acquire a birth certificate and also to register their death. Mr. Speaker, I want to ask all sober-minded Guyanese across the 83 square miles of this land to endorse, because not only the Amerindians and hinterland residents are affected, but also all the Guyanese who are living in this country who do not have that source document. This amendment bill will fix this issue. So I ask every Guyanese to support this amendment bill in its form, because it will bring relief to you and it will ensure that you will have the necessary source document. So, Mr. Speaker, I end by asking every Guyanese once again and the opposition members to support this amendment bill in its form. Thank you, Mr. Speaker.
I thank the honourable member for his contribution. I now call on the honourable member, Mr. Kemraj Ramjatan, for his contribution on this.
Mr. Speaker, thank you very much. And I want to immediately concur with the arguments made by Honorable Amanza Desir in connection with the timeliness or untimeliness, you can say, or the purpose or the mispurpose of this bill and the number of its clauses, especially that 5, but also to say that this bill has not the kind of thought that must go into bills of this very important, sensitive nature. And I want to commence by stating that if there was thought into it, and by the way, I did indicate this point to the Attorney General, it is the point of the very first clause, if I may say, where it says that the principal act is amended by the insertion immediately after section 33 of the following new section 34. Our section 34, although in those purple volumes, is stated therein as having been deleted by Act 21 of 1990, does not reflect that as being the reality. Section 34 exists, but not in these volumes because there was an error in the publication of that revised volume. And I'm absolutely certain that if there was thought gone into it, there would have been the citing, as it were, of that mistake. The act here is giving the impression as if we do not have an existing 34. And what it does, by virtue of this laws of Guyana, when you open it and you check 34 of the laws of Guyana, you see section 34 is deleted by 21 of 1990. Deleted. And what they are now doing is putting in that a parent may choose any surname for the child. Well, it is a mistake, and we must concede when mistakes are made, because the existing act that governs the situation, 21 of 1990, indicates that the surname of a child is generally that of the father if the father is married to the mother. And I understand also if they aren't married, the surname of the mother. And unless we have a scenario now where they want to add to that, a parent may choose any surname for the child, it's certainly going to bring a lot of confusion and conflict. When I take a look at Act 21 of 1990, and especially Section 24 to 25, we see that 24 amends Section 33. And when you take a look at Section 25 of the 21 of 1990 Act, it amends Section 35. I do not see anything there that deleted Section 34. Well, even if we do have Section 9, oh, no. I do see a Section 34. I do see Section 34. Well, I want... No, we're not apologizing. We have what is called a standard practice of surnames being clearly from that of father when you're married, and not being married, that of the mother. What we have here now, a parent may choose any surname for the child, is the same argument that we will be having in connection with the confusion that that will create. Which parent may choose any surname? Which parent? The mother or the father? And so that is rather sweeping a section in which you are now going to give a replaced or a reenacted 34, something that is very, very strange. Because we also understand, Mr. Speaker, that here the identity is also something that will make the child name who it is. Assuming now we have a parent say they would like to name the surname of the child Nandlao. That's or Jack Deo. You understand? Or Ramjatan for that matter. Or Kwame Mackay, or Mackay. This is giving a disconnect to that which can bring the history of the person who is now born, and so to associate that person with the parentage. And so this is also can bring a lot of confusion and probably, in my view, be another Trojan horse for a lot of mischief. And it will be an unruly horse and a slippery slope. Mr. Speaker, all of this especially is important for what we are talking about, the registration exercises that sometimes are so which is extremely fundamental for purposes of electoral democracy in Guyana. This can be, of course, a huge loophole that is being created by this administration for purposes of enhancing certain surnames and doing a lot of mischief. So I am asking that when you make it this sweeping, when you literally take away what is the practice and the prescription that we have been working along with for all the centuries, it is important that we must have had a defect in that century-long standing or centuries-long practice where the father's surname in a married couple or the mother in the unmarried scenario is settled. And so we do not have that situation whereby such a sweeping article is given legislative effect. A parent may choose any surname of the child. And of course, this construction or formulation of the thing also creates the confusion as to which of the parent. Anyone. So if you got the mother wanting another one as against the father, what happens? Why break the tradition of if the father is, let's say, Ramjatan, or whatever it is, that be the surname? I believe that by virtue of this now, and I want to believe that the entire opposition is of that view, that this thing got some mischief in it. And you do not allow that kind of prescription which was exercised for centuries now to be changed. Mr. Speaker, I want to also indicate that what could be done with that section, as was mentioned by Amanza, honorable member, is that we can insert that third category with the word that the parents must consent if they want to give any other surname but their names, their surnames, to what is already the practice of father and mother in the case of married and unmarried. And that can bring some sense to it. Mr. Speaker, I emphasize the fact that I haven't seen, whether it is in the speech given by Mr. Ben, honorable member, or the explanatory note, what is the defect? All it says is clause 2, by inserting a new section 34, provides for a parent to choose any surname for the child. That is exact replication of what is in the bill. That doesn't give any explanatory explanation, that is. It doesn't give any explanation. And so, what is that? What then is what is the defect? They didn't state it. It did, in relation to some other sections, they state that. And so I want to emphasize that fact, that indeed this is but something that is really disastrous about this bill, has certain suspicions, and we must try to address it here. It is far too sweeping, as I said. Mr. Speaker, in relation to the other section, section 35 of the Principal Act is amended by the substitution of a number of things that have gone into it. I want to indicate that we are hoping that there will not be the same person be given second identities simply because they could now go and do all that this section 35 as amended is talking about. It should not be encouraged. I see no preventative method in place to prevent a person repeating a change of name 5 years later. And of course, we have had situations where persons who previously changed their names return to request that their original names be changed back to that original. And so this kind of system that we are having here gives me a lot of suspicions. Take, for example, the second part of the proposed amended legislation where on registration no name has been given. This was corrected in the past by late registration. And after the expiration of 12 months following the birth of the child, that child shall not be registered without the written authority of the Registrar General. What I notice here, and of course, this is again, unless I am mistaken about it, This new system has no check and balance to protect it against corruption at the GRA, since the procedure does not require the Registrar General. What I see here is more or less an application made to any staff member there. We would like to see the Registrar General as the very important qualified head, like a person of good standing that they talk about in one other section. That person can have oversight over these. In relation to the amendment to section 43, that is very important, because you just don't go there and get the thing. Mr. Ben was talking just now about how there was massive corruption, and you're getting a lot of sealed birth certificates that are not genuine. And Mr. Honorable Member, the Minister. Yeah. So when you do that and you do not have the scrutiny of the the actual Registrar General, you're going to open up yourselves to a number of what is called loopholes, and it will tend towards major corruption. And all of that, as I said, the untimeliness of this thing is important, as was mentioned by Aman's honorable member. Mr. Speaker, I come now to the one that deals with this same section 5. Clause 5, the Principal Act is amended. You know, this person of high standing could be Mr. Nigel Dharamlal. He could walk in there and fill out forms and indicate, you know, he's a person of high standing, in inverted commas. And so you can have a number of persons who portray themselves as persons of high standing, just filling up forms. The thing about it is that we are not denying Amerindians or indigenous peoples their rights to be registered. But we must never use the pretext for this Trojan horse being the hardships in those areas, because that is exactly what can happen. And you can have, as elections results have been for the last couple of elections, very close, just arranging a number of these people, hundreds or a couple thousands, and you'd have a set of people who are not entitled to be registered. And that could be the system being broken and dismantled again. The dismantling of the guardrails of democracy being by virtue of that Trojan horse here. Mr. Speaker, our suggestion here is that there must be corroboration. Even if you want your person of high standing, you must have corroboration as another document corroborating from someone that is associated or knows of the birth. Not just somebody like Nigel Dharamlal, high-sounding or high-standing, and then they go there and they fill up the form and they say, well, fine, you're Guyanese born and you get a birth certificate. No. You have to have at least a document from somebody who is either, as the present practices again, and the prescription is, which is from some older person like an auntie or uncle or other sibling, grandparents, as was mentioned, neighbor, or some other people associated and closely connected with that, the awareness of that birth. And so it is important then that we just don't make these declarations coming from these persons, and then, you know, JPs and commissioners of vote who probably don't even know anything about the person. And you go, you get a lot of these persons who can just for a fee, they're going to sign it up. They don't really know anything. And it is clearly something that ought not to be. It is going to bring a lot of criticism even in those areas that Mr. Charlie speaks about, because it could be so loose that we can have from those areas the people coming in from not being born in Guyana or anything, overseas, Venezuelans in neighboring countries, Brazil and so on, or Suriname, and this happening. Or Russia. Or from any other country. And this is what we must be fearful of. This is what we must ensure that doesn't happen. And so the relief that must be given, as Mr. Charlie is arguing, is modernizing the administrative arrangements to ensure that genuine Guyanese are registered and be given birth certificates. And that is what the APNU FC had done by virtue of ensuring that we align our police departments with the various regions. They had their own, we had a method to ensure that at least the administration is going to be aligned with the regional system. And it was very much something that was useful, but also now going and carrying the GROs, the various departments there in those various regions, so that this kind of thing will not happen. Or if it does happen, at least a very, very few, almost negligible cases it will occur in. And it is very important then that that be the basis for ensuring that we have birth certificates given to those who are deserving as a result of our administering of those regions, or those what you might want to call ungovernable spaces, as it were. Get in there. And so it is very, very important, Mr. Speaker, because I see that this thing here got so much mischief. There are some sections that I would like to support, although I still believe that it's 45 days from the receipt of the application. If indeed somebody wants a sealed certificate, if we efficientizing the system, we should have it even earlier done. Earlier done. Why they want 45 days? Well, I think the existing legislation might have even less days than that. Mr. Speaker, I would also like to state this point about what is it that we are doing by virtue of wanting to create so much suspicions. This thing will cause tremendous resentment. This is not what I would regard as something that, you know, knowing that the opposition is a close runner-up in relation to the numbers game. Even when the PPP were in opposition, they came very close to. This kind of thing will create the resentment that thievery and corruption might be the basis now of going there to get the numbers. And I'm being very, very calm here. Yes, and the whole point of it is that it could be the opening for that kind of thing. And when people start understanding what this would mean, it is going to be disaster again, another disaster. And that is why we are here asking the government of the day to be engaged with the opposition. This is an important bill in which, in relation to such a sensitive matter, in relation to the registration of our people, giving them certificates to prove citizenship, being in accordance with the Rights of the Child Convention, and they want to modernize and so on, since they said that they like the fact of these international obligations, they're going to modernize. You don't want to call the opposition in to talk about these things so that we could probably at a select committee or some such committee deal with these issues? This is fundamental. And when we allow this slippery slope and this unruly horse to get away and start galloping, we're going to have probably a battlefield. It is important that they ought to have done a far better job of calling us in as an opposition, dealing with this issue of proper registration, and not creating, as beautifully put by Amanza Desir, a Trojan horse in which a lot of corruption can happen, and then the minister, Mr. Ben, saying that it is trying to curb corruption when you're creating such a big hole now for corruption. We will not support this bill. Thank you very much, Mr. Speaker.
Thank you, Honourable Member. Now call on the Honourable Minister of Parliamentary Affairs, Minister Gill, to share a contribution.
Of course, we seem to be consumed with levels of delusion that are astounding in this House. It becomes very worrisome when members of the opposition see jumbies under beds, behind windows, behind doors, and in bills before this House. It is rather concerning, but not surprising, obviously, because, as I say, when you're guilty of doing something, you then look for other people having done what you did. So this whole view of mischief and attempts at rigging and all these delusional words more is a reflection of the guilt on your part than on any intention on our part. But Mr. Speaker, laws are made based on reality and on social needs and to rectify obstacles and challenges to our citizens to be able to access services. One of the issues, of course, is one's identity. It's a fundamental issue of identity. It relates to patrimony as well in terms of your descendants and who you've descended from. But again, as in emancipation, people who came here as slaves were denied their identity, denied their patrimony, and in fact adopted names to have an identity of former plantation owners. So I don't understand this talk about patrimony and descendancy when in fact in the modern world, things have changed and laws have changed. And let's just look at a few of these things. For example, what are the social issues in this country? The number of women in this country who raise children alone, of absentee fathers, who when the children are born do not sign the green long registration form. So that's one issue. 29% of our households are headed by women raising children alone. The majority of those children do not have their father's name because their fathers don't sign the registration forms and cannot be made to sign those forms because the law, this law, the Principal Act says that both have to go and sign. And only when there's probably a DNA and the woman goes to court and says there's a DNA and he's the father, that it may lead to a correction or amendment of the birth certificate. So that's one fact. You have a social problem of children who are given their mother's names because they don't know who their father is, or the father denies paternity. That should concern us as a house, doesn't it? Shouldn't it? The second issue is a cultural one. We have in our country persons who are Indo-Guyanese, particularly the older generation, that were born with one name. One name, and the majority are women. And I stand corrected. We know that in 2008 house-to-house registration, that children had birth certificates, people who were adults to be registered had names that had to take a female Hindu name as their surname when they were males. And in many cases, they refused to be registered because they said they can't take that mother's name as a surname because that's a female name. And that problem continues to today. Because in the cases like that, there was no father who registered the birth or who signed to the birth registration form. So you have a particular issue, particularly among older women who have one name and their children have no surname or have the mother's one name, which is not a surname. Number one. That's number two social issue. The third social issue is that there are sections of the interior, not only Amerindian communities, but residents of faraway parts of the interior, who may have had a birth registration because in many areas and in most areas, and this was introduced in the 90s and again in 2000 and right the way through, that the health workers in the health centers and the hospitals register births in the communities. That's why you don't have a high percentage of persons who are not registered below the age of 20. You don't have that problem, a big problem there. You have a problem, but not a big problem. You have a big problem in the older generation, the 60-plus group, who were never registered. We haven't come to talk about birth certificates yet. We're talking about birth registration. If you don't have a registered birth, you can't get a certificate. And that is when the baby's born, or when someone goes, in the old days, people could go to the registrar and register the birth in that way, directly. The laws changed. And so the health workers have been given responsibility to fill out the green forms and fill them out and let the mother sign, etc. If the mother is delivered home, that has the different issues, particularly in Amerindian areas, where they may or may not be a health worker. But the majority today of our babies being born are born in the presence with health workers, health personnel, health practitioners. And therefore, automatically, the birth registration takes place because the forms and everything are there. There are, of course, situations where people in isolated areas where the baby may be born at home and they have to walk out to get the registration done. So those are three issues. There are bureaucratic issues too in terms of people applying for birth certificates, and they take a long time. Because in some cases, people didn't know that their birth was never registered. If your birth is registered and the forms came down to the GRO, it is easier to issue a birth certificate. So let's get straight some issues. There's also we're a world where I hear Mr. Ramjitan talking as if we're living in some long years ago to do with women's rights. We women today have rights, and we believe we should have those rights. And if there's no man in our life, why shouldn't we give the children a surname we want? Why not? Who's stopping it? And so, no, she may want to give him someone else's name that she likes. She may like a singer. She may like a piano player. She may like a drummer. It doesn't matter. It doesn't say that the name of the parent, the name has to be the father. It says a person may choose any name, surname for the child. And in the case of Indo-Guyanese, particularly older generation, and those that have one name, which are majority women, this allows the woman to put her surname to the name of the child. This is the 21st century. We can't go around the world with one name. It is about time that we have a first name and a second name. And so this is a simple amendment that would allow persons. What I think Mr. Ramjitan is afraid of, that men in this country may think that a woman will give the name of the person she thinks is the child father, the name. Well, they can go to court and battle it out. The issue is, because who knows who the father better than the mother? Right? Would you disagree with that, Mr. Ramjitan? The view really is only the mother knows who the father is. So the first issue is that a person may choose any surname for the child. A parent, sorry. And if you're a single parent or a one-name parent, that is a category that allows you to do that. It is a choice. However, if you're married and you like your husband's name and you want to keep it, then so be it. You also have situations with birth registration in Clause 3. And there are several things Clause 3 addresses. There are many people who are living together who are not married. There are also many people who are married who want to retain their names, both women and men. Therefore, we have a lot of hyphenated names in this country. I don't know how that comes about because our marriage law doesn't allow it, nor does the birth registration allow it. This bill will allow it. So if someone has married and has children, and either parent decides that they want to have that name as a surname or a hyphenated name, they can do so in the registration. Secondly, if there's no name for the child, and there are many cases that the registration at the health facilities, registered child born, male, 5 pounds, mother, name, father, no name. But the mother doesn't give the name of the child, doesn't give the name at the time. She wants to consult the book, she wants to go to the pandit, she wants to go to the imam, she wants to go to the priest, she wants to go to granny to figure out what is a good name for the child. The time passes, and sometimes, particularly for those living in faraway areas, and you can go just as near as Berbice River. I ain't even going far. Berbice River. The registration is there. She has the birth registration. She may even have a birth certificate that has no name for the child. And therefore, this allows, in the case of where there is a name that is registered, or where a child may have been registered, or where the registration has no name, that the parent or guardians can at any time after the child's birth be able to get a certificate and be able to insert the name. Because when you read the Act, when that doesn't happen, the parents have to go through a whole procedure that requires a legal recourse and cost. I've heard you talking here from the other side, but I wonder if you live in Guyana. I wonder if you've gone into some of these areas where the issue of birth certificates is a critical issue. And why shouldn't it be a critical issue? And why shouldn't we try to find an answer to it? If you don't have a birth certificate, you can't get an ID card. If you can't get an ID card or birth certificate, you can't get a passport. So, your identity. Let me give you the sad things that happen, because we're talking about, I heard Honorable Member Mansa Nazir talk about diaspora. and how people compare lineage and what village they come from and what family name they come from. I have been in the interior where a person dies. There's no birth certificate. Their birth was never registered, and therefore there's no death certificate. And therefore, you know what? They never existed. That is the logical conclusion. How inhumane, how unbelievable that in the 21st century we have people living to 60 and 80 years old and dying, and no document to prove that they exist. It's nice to talk here about Trojan horse and zombies all over the place. I'm not talking about any of that. I'm talking about real people. And this bill may not be perfect, but this bill tries to address the reality of people in various parts of this country, not only Amerindian areas and interior areas, rural areas, villages, who don't have the money, cannot figure how to navigate through the system. Because I know the GRO, I know the difficulties. Let me give you another example. A woman is born blind, and this is in the 1960s. She's approximately 18, 19 years old by 1992 elections. No birth certificate, no birth registration. In those days, you had a hard time, particularly with attitudes of the GRO staff. And so they said, bring us your mother, the woman who delivered you, some auntie, granny, someone who witnessed the birth. Her mother died. The midwife had long gone. No one knew where she was. She emigrated, and she was only child. It took 5 years and legal issues to get that young lady her birth certificate to prove that she existed. I think that the opposition has lost track. You've got lost in the woods, really, and woods of your own creating, because you've ignored the reality of our people. This issue has been around for a long time. Honorable Member Mr. Ramjatan was a Minister of Home Affairs like me, like Robson. This issue has been around. We've tried to deal with it from an administrative level, get the GRO to go out with mobile teams, get the system to work better. It hasn't really worked. And so there are people all over this country who statistically don't exist. Don't exist. So when you talk about a population of less than 700, we may very well be dealing with a population way over 800,000. We don't know. The only time we discover this is when we have elections and you're going house to house and you discover people who don't have an ID card. Why you don't have an ID card? Because I don't have a birth certificate. This attempts to deal with that. So you can see jumbies all over the place, and you can talk about who is high standing and moral standing. Read the act, read the bill. It says a person of high standing in the community where the person comes from. So as you try to say, my honorable colleague, Minister Nigel, I will be distributing birth certificates all over the place. If it's in his community and he is a person of high standing, why not? He cannot distribute. He can be able to witness that what is being said is true. But if he doesn't live in the community, he can't do that. And so this throwing of smoke and dust in people's eyes, I'd like to ask all the Amerindian comrades in this parliament if what we're saying is not true. As if we're not saying, is it true what Honorable Member Mansa Desir and Mr. Ramjatan is saying? Or is it that you know in your communities how many people, particularly the elderly, have not got a birth certificate because their birth was never registered? This bill allows, we've tried to find a solution to the problem. You got a better solution? Come up with it. You could have amended the bill if you thought your ideas were better than anybody else's. But the point is, this was an attempt to creatively deal with, by law, what is a major concern of people living in different parts of this country. And so, a parent may choose any surname. They can make up new surnames. The point is that in the birth registration, it will point to who the mother is. It will point to who is the maternal link, not the paternal link, maternal link. And in our society and in our laws, maternal and paternal links are equal. The point that Mr. Ramjatan says, honorable member, about only if people are married that they can have the children registered in both the father's and mother's name, totally incorrect. Informing this House totally. It requires the mother and the father to jointly sign. It didn't say anything about them being married. And this is a former Minister of Home Affairs under which the GRO came for 5 years. Mr. Speaker, the issue that's interesting in this bill, again under Section 3, Clause 3, 35(1)(b), that allows a child on attaining 18 years or more that either was never registered, was registered without a name, and so on, of going and getting registered. That's a major issue, because there are persons, not a huge percentage like the older persons, who are not registered. And this allows them at 18. At 18, you're an adult, you have rights under law and the Constitution, and you can exercise it, including being able to correct anything. The other thing that this bill tries to do is that to ensure that the Registrar General is able to come before the courts, which has been not the practice, and that my colleagues will go into the legal issues of that. One of the problems that I've encountered in the interior is that a number of people do get a birth certificate, but it has errors. It says they're a man when they're a woman. It reverses the surname and the first name. It spells the surname wrong. The process to correct an error not made by the registrant, but by the GRO, is a long and disgusting and frustrating exercise and expensive. And so that issue is being addressed in the bill. And I ask you to stop looking for jumbies and to read the bill with what its intentions are and what it does. So this bill addresses the issue of if there's an error in the certificate that you receive after you've applied, and this goes for across the country, anyone, that the process has been simplified. It addresses the issue of persons who have no birth certificate, who were never registered. When they die, how will the death certificate be issued? So in fact, they lived, they existed. The bill, I feel very passionately about the bill because, and I'm very proud of our government and our cabinet and our legal department and our Minister of the Attorney General, because this is an issue that has worried us for all these years. How to address these anomalies, how to address and let people have the fundamental thing they're deserving of is an identity. Identity. And have a document to prove who you are. The other thing, we just spoke about the adoption bill. We just passed that bill. And this bill before us now addresses the issue of adoption in terms of what was a discriminatory practice. The discriminatory practice was this, that if a adoption child's birth certificate was different than a regular child's birth certificate. This amendment removes all of that. So an adopted child's birth certificate is indistinguishable from any other child's. And that's an important aspect of their right to privacy and to protect their identity. The issue of time, of 35 days, 45 days, this is important. And before I forget the other aspect of time, this bill removes the old requirement, which was that if a year passes and you've not registered, have not a birth registration, that you now have to go through a long and expensive process to be able to get a birth certificate. That removes the timeline completely. So it is important to recognize that this bill deals and tries to address what are serious concerns and issues that people confront in our country. And I think if you were to imagine yourself, I'm sure all the members of this house have their birth certificates. Could you imagine if you never had one? Could you imagine that you have no document, you have no ID, you can't vote, you can't go to the bank, you can't do certain business, you can't get a license, you can't, how do you drive? Because you have to get your ID card. So how could you put yourself from moment and shove away the jumbies in your head and just deal with the human aspect of imagining what it is like to have no birth certificate, have no identity documents? And so, Mr. Speaker, maybe a time will come when men in our country, more men in our country, and all men in our country will accept paternity for the children they produce. And of course, there are ways that if they doubt it, they can deal with the courts. But Mr. Speaker, until that happens, we have to bring laws that deal with that reality. We have to bring laws that deal with that reality. Let me just comment on the Honorable Member Desir's Venezuelan claims. Mr. Speaker, let's go back. It seems as if and these are lawyers that spoke, and I'm not a lawyer. How do you get Venezuelans and Guyanese and Guyanese descendants who have lived in Venezuela crossing over the border, fleeing a situation there? The laws and the Constitution say that once one parent is a Guyanese, born Guyanese, the child is Guyanese, and you go through this process to have the birth certificate, overseas birth registration to be made. So a child can be born in Venezuela. Well, I know, because she's dealing with New York. But the issue is that a child is born in Venezuela of a Guyanese mother, Venezuelan father. They come over here as migrants. She has a right as a mother, because our Constitution doesn't distinguish lineage by a mother and father, either parent. She can go with the child's birth certificate the child was born in Venezuela, and apply for a Guyanese overseas birth certificate. And it is granted, and that child now, although from the time it's born, it has Guyanese citizenship, the piece of paper, the kaja, that allows you to say that you're Guyanese, comes with the birth certificate being issued, and subsequently ID cards and passports. And a large percentage of the migrants coming into Guyana from Venezuela are Guyanese. Those who left in the 70s, running away from rigged elections and banned goods, to those who left in the 80s and 90s based on their own circumstances. And so a lot of those are returning because things are rough. You also, to get the issue that is made about Venezuelans and talking about complicit to showers is highly offensive in this house. Because I didn't hear them talk about complicit JPs or commission of oaths or anybody else. Just 2 showers. Just 2 showers. And so the Venezuelans, you may think it's easy, but it is not for anybody to get a birth certificate or to register birth. Any child born in Guyana, any child born in our borders are Guyanese. So every Venezuelan or Colombian or Haitian or Cuban or American or British or Jamaican have children in our country and they're born Guyanese. Are you going to take that away from them? How can you? That's what our law says. We don't discriminate. And so all this talk about democracy, when you don't understand much about democracy and you haven't practiced it for a long time, or maybe never, maybe that's why you get confused. I remember in this house many years ago when the fair was about the Brazilians taking over. And I remember MPs from the PNC in those days, PNC R1G. And that was the name of the party. I didn't name the party that. It was PNC R1G. Wasn't that so, Brigitte? Right. Most appropriate, I must say, in looking at what has happened. But where MPs on the PNC side got up and was screaming the invasion of the Brazilians. And they will take over our culture, and we will be speaking Portuguese now. Well, that was around 2000, 20 years later. It hasn't taken place. Just like the screams about the Chinese and the Indians, and now we're dealing with the Venezuelans. And so our laws and our society is a hospitable and a humanitarian one. And this is where we come in with the Venezuelans. A Venezuelan who is born Guyanese but took on Venezuelan citizenship has a right to their child, wherever they're born, to become Guyanese. Any child of a Venezuelan or any other nationality born in our country becomes Guyanese by a process. And so this level of, as I said, looking for Jumbie under every bed, behind every window, will run you mad. I'm warning you. One last thing, in terms of universal registration birth certificate, in 2011, UNICEF and the president of Guyana, Mr. Jagdeo, signed one of the declarations which was globally signed by leaders and heads of state to do with universal child birth registration. At that time, the study that was done showed that we were 80% of all of our children in Guyana born between the ages of date of birth to 5 years old were registered. And this was thought as a good achievement and one that assisted in children getting registered into school. This is a process we've continued right through, and I hear again the honorable member say we're 85%. So we still have to continue to struggle to make sure that every...
Honorable Minister, for you to continue, you'll need an extension.
Mr. Speaker, I rise to ask that the honorable member be given 5 minutes to conclude her presentation.
Thank you, Honorable Minister. You may continue to conclude.
Just in response to mischief afoot, that mischief was afoot, and that let me just remind this House that in 2019, 500,000 birth certificates were purchased by the former administration, by Office of the President, for 500,000 birth certificates that cost almost $300,000 US for the registration period that never took place. And that outside of the procurement process, which was illegal, and it defied the fact that this is an audit going on now, why did we need 500,000 birth certificates in 2019 on the house-to-house registration, which was supposed to be planned for October, November 2019. And where did all those birth certificates go? What happened to all of them? And by the way, the person who got the contract was one of the elite in the office of the president. Yes, the director of parks, so I understand. And so when we talk about mischief afoot, as I said in the very beginning, I think that the opposition members who've spoken so far are talking from a guilty conscience. They're talking from a guilty conscience that they are thinking that the PVPC will do what they have done and what they did and what they tried to do in 2019 and 2020. And let me make it very clear, Mr. Speaker, this bill is to help our people who have no identity, no certificates, to be able to get registered. It modernizes the system to make it easier. It modernizes the recognition of male and female roles in our society. It recognizes the cultural issues in our society. It gives women rights to be able to name a child as they so wish. And Mr. Speaker, there are no jumbies. There is no mischief. If there is any, it happened in 2019, 2020. Thank you very much.
Yeah, lovely, lovely. Excellent.
Thank you very much, Honorable Minister, for your contribution. I now call on the Honorable Attorney General and Minister of Legal Affairs, Mr. Anil Nandlal, SC, to make his contribution.
Thank you very much, Mr. Speaker. I want to begin by thanking my esteemed colleague, senior colleague, Madam Gail Teixeira, for laying a solid foundation in her presentation and addressing a lot of discrepancies and inaccuracies which we heard emanating from the other side. And by so doing, she has made my job appreciably simpler. Mr. Speaker, it is no doubt, and rather it is no secret, that globally there is a problem with the inability or failure of countries to have their citizens registered. It is a global dilemma, and the United Nations has recognized it. So what we are doing here, in essence, Mr. Speaker, is satisfying our duties under treaties we have signed at the level of the United Nations. I want to commence, Your Honor, by pointing out that a child's right to have a name and be identified by that name is a right under the Convention on the Rights of the Child. This is one of the conventions mentioned in the 4th schedule of the Constitution of the Cooperative Republic of Guyana. Article 154A states, subject to paragraph 3 and 6, every person as contemplated by the respective international treaties set out in the 4th schedule to which Guyana has acceded is entitled to the basic human rights enshrined in the said international treaties, and such rights shall be respected and upheld by the executive, the legislature, judiciary, and all organs and agencies of government where applicable to them, and by all natural and legal persons, and shall be enforced in the manner hereinafter prescribed. Sir, this bill comes out of that constitutional obligation that devolves upon Guyana as a signatory to that right of the Child Convention, and by incorporating that convention expressly as part of our Constitution by virtue of Article 154. We have no other duty here but to implement the convention in the way that we are seeking to do. Now, Mr. Speaker, I want to also point out that the United Nations Sustainable Development Goals list 17 goals with 169 targets that all UN member states have agreed to work towards achieving by the year 2030. The UN Millennium Development Goals have been superseded by the Sustainable Development Goals. The adoption of Sustainable Development Goals by United Nations in September 2015 placed birth registration formally on the international development agenda. It included a dedicated target under Goal 16, which is to provide legal identity for all, including birth registration, by the year 2030. What we are doing here, Mr. Speaker, we have a duty to do. Under UNICEF as well, there are a series of obligations which devolve upon Guyana as a country. And I'll read them very quickly. 1, provide every child with a certificate upon birth. 2, empower all parents, regardless of gender, to register their children at birth. Where is Mr. Ramjitan? Empower all parents, not fathers, all parents, to register, regardless of gender, to register their children at birth. And I'll get to explain how each of these provisions relate to our international obligations to silence and put to rest the bogey arguments and the jumbie arguments we have fabricated on the other side. Thirdly, link birth registration to social services. Fourthly, invest in safe and innovative technological solutions to facilitate birth registration. We are not even doing this. We are still using traditional methods to register. And we are being criticized here because we still have to go into the interior where we can't use the technology that is contemplated by our international obligations under the treaty. But at least we are trying to use traditional methods and methods that are available to us to achieve these objectives, and an uninformed, reckless, and irresponsible opposition who do not read anything come here and criticize us. 5, engage communities to demand birth registration for every child. Sir, does these things ring a bell? Do they ring a bell? We speak about our Amerindian communities. We empower the Tushals. This is exactly what the international obligations are that devolve upon us. So this bill, Mr. Speaker, must be situated and predicated into that context. Nobody at the Attorney General office sat down with any sinister motive and devise a compendium of provisions and bring them to this house. What we are doing here is to give effect to Guyana's international obligations, which we are all required to do. And that is why I read from the Constitution. It binds the executive, the legislature, and the judiciary, and every other organ of state to do what we are doing here. So I hope that I have laid a solid platform to reject out of hand the scurrilous and ridiculous arguments that we have heard from the other side. So let's deal with the first right. First of all, my distinguished and learned friend, the Honorable Mr. Ramjitan, started a very fiery argument about Section 34 being inaccurately reflected in this bill. And as usual, he was comprehensively wrong, and I believe he admitted that when I pointed that to him. So the entire presentation of his began on a falsified and false premise, and it continued that way until the end. Section Clause 34, sir, says, it's a one sentence, sir. It says this: a parent may choose any surname for the child. Mr. Speaker, we heard a lot about maintaining family name, maintaining tradition, maintaining family values. And those who are espousing those sentiments were shockingly two lawyers who failed to recognize the misogyny in what they were saying, the chauvinism in what they were saying, the discrimination in what they were saying, the sexism in what they were saying. You know what they were saying, sir? That the male gene alone must be allowed to continue generations after generations. That the women must remain shackled as a second-hand or a second-class gender. That their gene must no longer be carried on. After 200 years of backwardness, they want us to continue in that state of regression and stagnation. And two lawyers are saying that, not recognizing that what we are doing here, a day after Freedom Day, was liberating our women, freeing our women. That is why, you know, we mustn't wear the clothes and do the dance. We must understand the philosophy, or else we will remain shackled to mental slavery. So, Mr. Speaker, what we have done here is to empower women as men are empowered to choose the name that they wish their child to bear. My esteemed colleague, the Honorable Gail Teixeira, spoke about the social problem in our country, the child father and the single mother phenomenon, which exists right across the length and breadth of our country. And when that single mother goes to register and does not find or can't get the father to go, what happens there is that the registrar is enjoined to leave that space where the father's name has to be inserted as not stated, or leaving it blank. So that child is left with a single name. We want that to continue. We want that to continue. Any lawyer who has ever practiced in the courts of Guyana would tell you how many times mothers and families come to them with birth certificates where there is no father stated. This is intended to correct that. And the parents can choose. The mother and the father can continue the tradition if they wish to have the father's name going on or being reflected there as the surname. But the issue is that now there is a choice. The woman can choose the name as well, which is to bring equality to our sexes and gender, to remove the shackles of discrimination that are embedded across the legislative landscape of our country. I spoke about it when I spoke about in the previous bill, that we will be removing these archaic concepts and anachronistic doctrines that are deeply rooted in our legislative landscape. And that is exactly what we are doing. And you know, we inherit this from the United Kingdom. This was part of a convention in the United Kingdom. And do you know that the United Kingdom itself has abolished it? But my friend Mr. Ramjatan wants us 60 years after colonial rule has departed these shores, for us to continue to be colonized in the manner that they did 100 years ago. So, Mr. Speaker, this simple provision is to empower the women to have a name there. And thank you. You come back. I hope you listen attentively. Mr. Speaker, in the modern world, people are free to change their name to a sign. The rock star and the famous people do it. I recall the singer Prince. He changed his name to a style. And the laws of America allow that. People can change their name to anything. That is their right. Yes, look how much time you change your name. PNCR, PNC1 reform, PNC again, APNU. Nobody's stopping you. Why you want to stop the mothers of this country? That is all we have. And that will remain because there is a brand with integrity and authenticity. So, Mr. Speaker, I hope that I have answered that singular question, that the questions that singular sentence seemed to have evoked on the other side. Let's go to the next clause in the bill, clause 35. Mr. Speaker, we are replacing section 35 in the Act with a new clause. And all we are doing here, Mr. Speaker, let me read it quickly. When any name has been given to a child by its parents or guardians other than that by which it may have been registered, or where on registration no name has been given, the parents or guardian at any time after the child's birth has been registered, or that child attaining the age of 18 or more may deliver to the registrar Form 3 and request a change of the name. All this seeks to do is to remove a time frame. Right now the law is that if there's a mistake in the name or there is no name registered, the parents can either go to the registrar within 12 months and effect the change. Outside of the 12 months, you must go to a magistrate and give the magistrate the particulars requesting the change. The magistrate make an order and you take that order back to the registrar and you get the change done. We are removing, one, the time constraints. So the parents can go at any time. Why 12 months? And we are removing the requirement to go to a magistrate. A magistrate has nothing to do with this. Why a parent's got to go to a magistrate after 12 months expire? But before 12 months, she could have gone to the registrar herself. Does that make sense? So we are removing the period and the 12 months period, and you don't have to go to the magistrate. And importantly, we are now empowering the child itself upon the attainment of the age of 18 to go and change that name or to correct an error that is in that birth certificate. What is wrong with that? What is heinous about what I don't understand? What is suspicious about that? What is sinister about that? We are simplifying the process, and that is one of the identified reasons globally for this problem that we have, that there are not a high incidence of registration, or not high as it should be. Why? Because we have across the Commonwealth, in particular, some very archaic legislative requirements. What we are doing here is simplifying them. And each sovereign country is entitled to, and in fact has a duty to, craft the type of legislation that best suits the peculiarity and the idiosyncrasies of that particular society. And that is why we are crafting our own mechanism, and we are putting in who have influences in the far-flung areas of our country, they too shall. There's nothing sinister about that. Absolutely nothing sinister. It's to make it easy. And let me make the point that my Madam Teixeira has made repeatedly. I don't know who on that side do political work, but we on this side, we do a lot of political work, house-to-house work. And every single election, in every single community, no matter how you comb it from one end to the other, the next election, you go back and you find somebody who is not registered. And they have no birth certificate. They have no evidence of registration, none. And I'm telling you, you can go from Crabwood Creek to Charity, and you will find thousands and thousands of them, although we have been doing so many registration processes across this land. And that is the reality. This is intended, yes, to correct that. Because every person has a right to be registered. Let us move now to clause 4, which amends section 43. Here, this is a very important section. And Mr. Ramjatan, listen carefully. Here we are first limiting, listen to me carefully, we are limiting the type of error that the registrar can correct on a birth certificate. He can't correct any error, only a minor clerical error. Why? And let me tell you the wickedness that we are trying to cut out here, because you're accusing us of doing wickedness. In fact, what we are doing here is excising wickedness. What we find in the court system in particular is that persons, as you know, can go to a magistrate and make an application to correct what is considered under the law a minor clerical error. But what they go there and do is that they remove Ramjatan as a surname and they replace it with Nandlal. That is not a minor clerical error. That is I didn't say it. Now that is a serious problem, because you have people using the court to actually perpetrate fraud in getting sponsorship done, altering their ages, and altering different particulars in that birth certificate in order to achieve some sinister ulterior objective. What we are doing here is putting a safeguard, a safety mechanism. We are limiting the category of errors from any error to minor clerical error only. No, I'm not taking away the magistrate. Wait, listen to me. I'll take you step by step. And we are doing that for death certificate as well. And then the bill outlines how the registrar must effect the correction on the document itself as well as on the other records. So when you go in to the registrar, there is a complete inventory and history of all the errata, all the errors, all the corrections made to your birth instruments and your birth records. They are all in one bundle. That is what this seeks to do, to make the process transparent and accountable. The third issue that this clause deals with is this. Currently, as you know again, you make the application to the magistrate. The magistrate hears only the applicant, but the magistrate makes an order based upon the application, which order is directed to the registrar of births and deaths for the registrar to correct the register. What the registrar in this process is not heard, so you have a flagrant violation of the rules of natural justice, but the registrar is presented with a fait accompli and is expected to carry out the orders of the magistrate. Now let us say, as I said, the registrar is not consulted, so no one knows what is in the registry already. So an applicant comes and says they want to correct their birth date from 1973 to 1975, and they want to correct their first name or last name from Thomas to Thompson, without hearing the registrar and without consulting the records that are already in the system. That magistrate, upon hearing the applicant alone, grants the orders. The registrar now is presented with a fait accompli of complying with what the magistrate just granted. But when the registrar consults the actual register, the date of birth is registered there as 1973, and the person's real name is Thomas, not Thompson. The registrar now is exposed to contempt of court, or to vilify his own desecrate his own records that have been there since 1973. That is a practical and pragmatic problem that we have been facing for the past 30 years. As a lawyer, you know about it. You did nothing for 5 years. So congratulate us now for doing it. That is what this bill is about, Mr. Ramjatan. It's not about rigging elections. We don't do that. You do that on that side. Let us go to the other bill, the other clause in the bill now. Clause 5. This is the one that my esteemed and most learned colleague on that side describes as a Trojan horse. My friend, here is where, as I said, and seasoned politician, my colleague, the Honorable Gail Teixeira, spoke about it, where we have persons right across the length and breadth of this country, on the coastal plain, but more importantly and more prevalently in the far-flung interior areas, where there is no registration, there is no birth certificate. What do you do? There is no record to which you can consult. You think the people in Pacaraima Mountains got clinic cards? I don't understand where these people live. Who are making these arguments? You think the settlement at the bottom of the Kanuku Mountain got any paper pasted on a wall? Or that has any birth particulars? No, my friend. Come back to earth. We have to make it possible to gather whatever information there is available, to put it there to get the persons registered. Yes, but sometimes, my friend, you may not have anything to corroborate. And as far as possible, I put corroborative elements. Corroborative elements are in the bill. Let me read it to you. Where an adult requires a certificate of birth and there is no original documentation containing particulars of his birth, or there is no record of his birth, the Registrar General shall issue a certificate on birth on the basis of the following documents containing particulars touching the birth. Now, if somebody where the Honorable Prime Minister went the other day, is it Gunmouth? Guns? Guns. You know where Guns is, Mr. Ramjitan? You can't go there other than by a chopper. You understand? Good. You think, other than a tushao or an elderly person in that village, who you think have any record of the birth of a person who has never been registered? Why don't you pay attention to the peculiarities of your society as a leader and come up with exigent plans that can address the anomalies that exist in your country, rather than come here and criticize us and attribute dishonorable motives to us? Compliment us for being innovative, something that you couldn't do as Minister of National Security. So, and that is what this clause does, every part of it. We have empowered about 3 tiers of people. Prominent community leader to show there's a justice of peace, there's a commission of votes, all of them corroborating each other and compiling a document upon which will form the basis upon which the registrar can act to create a birth register. So, and the same thing for death certificate as well. And then, right now, one of the big problems that we have in Guyana, and you can ask any persons who have filed their application to register a birth or a death, there is a time frame problem. They go and check at the post office every day and they're told you got to come back, we will send it to you in the post by registered post, and the thing never comes. What we are doing here now is to fix a statutory time frame that can put regularity, predictability, and uniformity into the system. And yes, we had to come up with 45 days. And how did we come up with it? We looked at the system, the registrar spoke, he gave us an estimated time frame that his department will take or his machinery will take to process the documents, and that is how we come up with 45 days. We didn't pluck that out of thin air either. But it's better that we put a time frame. It may be a little longer, it may be a little too long for some people, but it's better than leaving it open-ended and you have to wait infinitum, ad infinitum, and you never get it. This here creates a mandatory obligation on the registrar to ensure that once the registration forms are filed, his system has 45 days to produce the ensuing or resultant document, which is the final certificate, whether it be birth or death. And importantly, in the interregnum, we made a provision. So careful and thoughtful that we are. You accuse us of not putting enough thought into this. We were so thoughtful and we were so careful that in that interregnum, we also provide for a document that can be used for official record purpose until the real document is issued at the end of the 45 days. That is the kind of thought that went into this bill, Mr. Speaker. So the other side is completely out of place when they made those reckless statements and comments about the bill. And the last provision in the bill is the one that I have already alluded to, which is the removal of discrimination from the certificate, birth certificate, that relates to a child who is adopted. So that that child, of course, the record is there to show an adoption. That is always here, but that will be highly confidential and protected in the interest of the child. Not available for the public, but the child can eventually get it. That's the whole purpose of archiving those records. But a member of the public will not be able to detect whether that child has been adopted, in protecting the integrity of that child and from preventing that child from being exposed to discrimination, etc., etc. So, Mr. Speaker, I say to this House that every single provision of this bill has been thought out. It is a remarkable step in taking us forward, in advancing our obligations under the Rights of the Child Convention and the United Nations Development Sustainable Goals. And also, Mr. Speaker, the principle The principal act, the Births and Deaths Registration Act, was passed in the United Kingdom in 1868. 150 years ago. By sheer passage of time, it has to be amended. And I am proud, Mr. Speaker, to be associated with this regime of amendments. Thank you very much.
Thank you very much, Honorable Attorney General, for your contribution. I now call on the Honorable Member, Mr. Dionarain Ramsarup, to make his contribution.
Thank you, Mr. Speaker. First, I would like to take this opportunity to wish all Guyanese a happy Emancipation Day. And I also want to express my sincere condolences to our staff that has passed away. Sir, if I to rebut what the AG said, and I hope he was not quarreling on me, and the Honorable Madam Chief Whip, we could go beyond time. But both explanations, Mr. Speaker, when I look at the explanatory memorandum here, nothing is within this here, the explanation. Mr. Speaker, we are not, I want to make this quite clear, that we are not against any discrimination against gender or any international obligation. None whatsoever. I want to make that quite clear. And I think then my former speakers and my colleagues did not mention that. Sir, indeed it's quite right that after 23 years plus one, this bill has finally arrived here to deliberate these changes here. And I'm certainly sure, Madam Chief, it didn't come from the space. And the question that the AG speak about, the problems with the birth certificate and persons during the election period, that every time you go, you always find problems with registration, birth certificate, ID cards, etc. But who is responsible for that? Who is responsible for that? And that, Mr. Speaker, is the question that I would like the Honorable Minister of Home Affairs to answer. Mr. Speaker, as I rise to contribute to the Registration of Birth and Death Amendment Bill number 10 of 2021, the registration of birth and death is an improved framework that overhauls and streamlines the registration of two events that book and end every human life, as it were. This provides government, in the event of birth and death, under a wide range of foreseeable scenarios. Even though that some of the changes are necessary to allow for ample time and ease of getting certain changes without the legal hassle, I have a few clarifications to seek. Mr. Speaker, firstly, I would like to turn your attention to the insertion of the new Section 34 of the Principal Act, which reads that a parent may choose any surname of a child. Mr. Speaker, with respect to surnames, these are allowed and provided for under the new Act and its processes. In the current registration of the birth, a child's surname is given. Although there is no explicit reference to double-barrel surnames, currently parents can register their child with double-barrel surname if longer any reference to surname. Could the Minister of Home Affairs, the Honourable Member, Mr. Robinson Ben, give us some guidance on the surname that will be permissible for the child, the kind of surname that will be permissible for the barrel race designation. And this is where it gets complicated, Mr. Speaker, because you're talking here about not only the birth of a child, but you're talking about interracial marriages and all these things. How would you determine that surname for that child, Mr. Speaker? It's complicated. So that is what we are trying to explain here on this side of the House, that the further you examine these clauses, is the more complicated it gets. Mr. Speaker, when I talk about this barrel surname, or when you talk about any parents can select a name, are you going to put it in a paper bag and shake it up and say, pull the name out? That is what I'm trying to find out here. And I'm hoping that the Honorable Minister can explain this to us. What happens to inter-ethnic marriages that seems to be on the increase throughout the world and in Guyana, especially here, Mr. Speaker? It is important for children of such unions to have the opportunity to grow up with an appreciation of their mixed percentage. If the parents choose to signify that by choosing double barrel race classification for theirs, I am conscious of this. For example, if you have an Amerindian and an Indian that birthed a child, how will that child race be recorded? Shall the parents have choices to choose the surname of that child? This becomes complicated. You have to check your ancestry. I hope you go to India to find yours. I wanted to insert, Mr. Speaker, I wanted to insert Ramswarup as the law prescribed. Do I have to take a lawyer now to act as a mediator to do this? This can further compound the issue by doing my ancestor unjust. I would certainly like to know where my foreparents came from. Our future generation, Mr. Speaker, is in jeopardy if we continue in this path. Mr. Speaker, I can recall our former president, Dr. Barajagli, who went to India to find exactly where his foreparents came from. But if we continue to do this amendment here, Mr. Speaker, we are going to wipe the history out. Sir, amendment of Section 35. This looks straightforward, except that the amendments are being considered without reference to the entire document, with its entire contextual framework. An individual can legally register under the National Registration of Registrant for the purpose of an ID card. Once that individual is 14 years old, upon the submission of the birth certificate, that person's name is entered on that registration. This ID is then issued once an individual attains 18 years. For the purpose of the voter registration and to vote against the general and to vote at the general and regional election and at local government elections. Mr. Speaker, my question is, what provisions are being put in place to prevent duplicate registration at any time by just making a declaration and obtain a new birth certificate in a different name? You're going to have scenario, Mr. Speaker, where persons will be having two ID cards. What provision is there for that person to surrender that ID card? And that is what we have to clarify, Mr. Speaker. Mr. Speaker, well, I don't know how the ID card come, because, Mr. Speaker, and in a correction mode here, is that the Madam Chief Whip said that you cannot have an ID card, you cannot have a passport with an ID card. But my first document I had was a passport, Mr. Speaker, at age 16. You said without the ID card. Mr. Speaker, Section 44A1, where an adult requires a certificate of birth, and there is no original documents containing the particulars of his birth, or there is no record of his birth, the Registrar General shall issue a certificate of birth. This was done at the discretion of the Registrar General after the production of proof that the person was indeed born in Guyana. The question is, who is the person of high standing, Mr. Speaker, and what does that person know of the birth of the child or person? The proposed legislation does not say anything about that issue, Mr. Speaker. This issue of substantiation birth is not always the preserve of a person of high standing in the community, but by a person who associated with the birth of the child, example, aunt, uncle, older siblings, grandparents, neighbor, and a number of other persons in the community who are closely connected to the parent at the time of the birth. This term, persons of high standing, has no place in this legislation unless they were associated with the birth of the child or persons. That should be removed. Mr. Speaker, we have to be cognizant of several cases on the Guyana-Brazil border that this bill seeks to address. The Guyana-Venezuela border, the Guyana-Suriname border, which is the New River, where Guyanese live in Venezuela and Brazil illegally, giving birth to their child, then return to Guyana and pretend that the child were born in Guyana. And by using this to show as a connivance attempt to register the child as though they were born in Guyana. This becomes a citizenship issue, sir. A citizenship issue. There are countless numbers in the Mazaruni border with Venezuela in this issue. Mr. Speaker, the Guyanese in Region 9 regularly do this act, and a method of correct it ought to be found. Some Guyanese travel to Brazil for work, for the medical treatment, and they give birth to in that country, but either cannot go or do not get their children registered, but seek to do so in Guyana. The New River situation is different. They have to give birth in Suriname, where it is easier to access than anywhere in Guyana and acquire good medical attention. It is suspected that the amendment, Mr. Speaker, proposed at Section 34, 35, and 44A are to capture those members of the indigenous community for electoral purposes. There are also Guyanese who previously migrated to Venezuela, changed their names and other details to secure Venezuela identities. Since the crisis in their new homelands, are they returning to Guyana with Venezuelan passports and requesting their Guyanese identity to do so, would be creating one person with a Venezuelan or a Guyanese identity. This should not be permissible and should not be supported. I therefore, Mr. Speaker, ask and recommend strongly to this House that this bill be put before the Special Select Committee for further deliberation, sir. That will be my strong recommendation here today. Sir, we are trying here our best to find the loopholes that we supported some of these clauses here, like as you was talking about the 45 days and the 12 months period and the minor clerical correction. We have no issue with that, Mr. Speaker. But between these clauses here, there are some hidden agenda. There are some hidden agenda that they want to bring forward and try to pass all these bills one time. Mr. Speaker, if you look at the number of bills that are trying to pass within this 2-day period, or probably today, it's enormous. And why would we want to do this? We're going to come back on Monday, sir, don't worry. Sir, I am urging and I strongly recommend that we carefully examine. I know you like me. Mr. Speaker, I am urging that we take this bill, urging you that we take this bill to the Special Select Committee for further deliberation, sir. And I thank you very much for your time.
Thank you, Honorable Member. And I now call on the Honorable Minister of Home Affairs to conclude the debate.
Mr. Speaker and honorable members, I am indeed surprised, given the context of the bill, the clear things that it has to set right and will set right, the fact that the Honorable Attorney General just said how many years since these issues were played up in other jurisdictions. I am, of course, maybe not simply surprised, because I think that it is clear now that the members on the other side, mostly, in their presentations, indicate clearly that they're suffering from a guilt complex. They are suffering from a guilt complex. They're seeing zombies and conspiracies and hidden agendas and all kinds of ridiculous things in respect of what clearly in the recording, in the presentation on the bills, in the information presented by the Honorable Attorney General or a member from Region 9, and the impassioned presentation from the Honorable Gail Teixeira, why this bill is so necessary. And it's ridiculous, some of the things people are saying here. If I were to just start with what was just said, maybe just let me make it simple. I've said here before in this house, Honorable House, that my mother laughs and says to us, if my father hadn't married her, my name would have been Dos Santos. Yes, Dos Santos. Dos Santos. And, Mr. Speaker, I have a mixed marriage. And each one of my children, my 2 children, has a Muslim name. Apparently, people have some impression that if you have simply a name, it always identifies who you are by racial origin. And this is not necessarily so in our Guyana, which is getting more and more united. And so the notions, the presentations which were made in respect of these issues on the other side are disappointed from the point of view where I thought in the beginning that on that side they were prepared to support the bill fully. They were prepared to support the bill. But given the first presentation from Ms. Desir and the confusion in their presentations thereafter, it was clear that instructions came from elsewhere at the last moment. Mr. Chairman, Mr. Speaker, I'd like to remind ourselves that issues of the Trojan horse, in fact, that horse already bolted in relation to what the AFC wanted to try the last time. But they come out from mythological issues in relation to the Greeks and the Trojans. And the suggestions, high-flung and high-sounding as they are, have nothing to do with what the intent and purposes are here in respect of these bills, this bill. The Honorable Attorney General was at pains to point out clause by clause what the meaning of in respect of the bills. The Honorable Gail Teixeira, impassioned as I said, pointed out the social, the gender, and other relationship issues which are positive and progressive in relation to the adoption of this bill. I can only suggest to ourselves going forward that in relation to issues of gender, of women, as the Honorable Gail Teixeira said, and the Honorable Attorney General said, in relation to the question of our identifying and certifying the humanity of our Amerindian peoples and peoples in the interior, that we have this responsibility to pass this bill here today in this House. The humanity of our Amerindian people, our First people, and others, older people, people, as it was said, who may have been blind, who have the royal runaround in respect of getting a birth certificate, and therefore the other services which are requisite for each and every Guyanese at particular stages of their life cycle. So, Mr. Speaker, I want to thank my colleagues on this side of the House for their excellent presentations in relation to supporting this bill. And I want to commit this bill to the House for its approval. Thank you.
Thank you, Honorable Minister. I now put the question that the bill be read a second time. Those in favor say aye. Those against say no. The ayes have it. Let the bill be read a second time.
Registration of Births and Deaths Amendment Bill 2021, Bill number 10 of 2021.
The House will now resolve itself into committee to consider the clauses of the bill. Honorable members, I now propose the question that clauses 1 to 7 form part of the bill. I now put the question that clauses 1 to 7 form part of the bill. Those in favor say aye. Those against say no. The ayes have it. I now put the question that the bill as printed be reported to the House. Those in favor say aye. Those against say no. The ayes have it. Let the Assembly resume. Honorable Minister of Home Affairs.
Mr. Speaker, I rise to report that the Registration of Births and Deaths Amendment Bill 2021, Bill number 10 of 2021, was considered in committee clause by clause and was passed without amendment. I now move that the bill be now read the third time and passed as printed.
The question is that the bill be read a third time and passed as printed. I now put the question. Those in favor say aye. Those against say no. The ayes have it. Let the bill be read a third time.
Registration of Births and Deaths Amendment Bill 2021, Bill number 10 of 2021.
Honorable Prime Minister.
Mr. Speaker, I move the adjournment of the Assembly to Monday the 9th of August 2021, starting at 10 hours.
Honorable members, the Assembly now stands adjourned until Monday the 9th of August at 10 a.m.